A lot of my clients right now are trying to apply for employment authorization documents or work permits because they think that having a work permit protects them from deportation. And the answer is that it generally doesn't protect you from deportation, but it depends. So there are different categories of work permits, like more than several dozen categories of work permits actually. And it depends on what the underlying status is with the work permit. The work permit by itself offers no protection. So even if you just got a new work permit in the mail, the common thinking is, oh, then the Department of Homeland Security clearly isn't trying to deport me. They like me. They just gave me a work permit. But that's not exactly true. So let's go through a couple examples of ways in which you can get a work permit. So one of the most common ways in which people get employment authorization documents is when they have a pending application for adjustment of status. In other words, if you have a green card application pending within the United States, simultaneously you can apply for a work permit in the C09 category. This work permit doesn't by itself offer any protection, but the pending adjustment of status application usually offers some limited protections. Having a pending adjustment of status application does not 100% guarantee that you're protected from removal or deportation from the United States. But generally speaking, if history is any predictor of how ICE will behave today, which is questionable, when an ICE officer sees that you have an adjustment of status application pending, they usually don't pursue you for removal from the United States, because one of the defenses that you can assert in removal proceedings, in deportation proceedings, is adjustment of status. That's actually also a defense from deportation. So it doesn't always make sense to try to target someone who's otherwise deportable when they have an adjustment of status application pending. But it doesn't actually matter whether or not that person has an employment authorization document or not. What matters is that they have an adjustment of status application pending. Another common category in which people receive employment authorization documents is people who have TPS, which means temporary protected status. Temporary protected status is actually a valid non-immigrant status that's in the Immigration and Nationality Act. And it basically means that the government's not going to deport you for now as long as you are in valid TPS status. And you also have the option to apply for employment authorization. You can actually have TPS without applying for employment authorization. It costs a little bit less to apply if you don't want a simultaneous work permit, but I would say 99% of people who get TPS also apply for the work permit. Again, the work permit here is not what gives you the status. The TPS is what protects you, not the work permit. Some people also have DACA, Deferred Action for Childhood Arrivals, which was an Obama-era program that's kind of being phased out. If you don't already have DACA, USCIS will not accept new applications for DACA. And again, same thing as TPS. DACA, unlike TPS, is not a valid non-immigrant status. It's not in the Immigration and Nationality Act. It was a creature of executive order. Obama basically said, if you sign up for DACA and you're approved, you need to meet some requirements. You need to have like an education or military requirement, and you can't have any serious criminal history, and you must have been brought to the United States when you were a child, and there's cutoff dates and all that stuff. When you have DACA, the first two letters in DACA are deferred action for childhood arrivals. But the deferred action basically means that you're going to be deprioritized for removal from the United States. People who have DACA generally don't have to worry about being removed from the United States. Interesting fun fact, if you have DACA and you are in removal proceedings, the immigration judge will generally not recognize your DACA status because it's not a valid status in the Immigration and Nationality Act. But historically, the Department of Homeland Security will not continue or pursue removal of someone who has DACA status, and they would generally agree to dismiss the removal proceedings. I haven't seen that play out recently since Trump was elected, but that's historically how it's happened. People who have DACA, just like TPS, can also apply for employment authorization. But again, that employment authorization by itself offers no protection. It's the DACA that offers some limited protections. The final category that I'm just going to talk about today, in which many people receive employment authorization, I would actually say like millions of people in the United States have employment authorizations in this category, is when you have an asylum application pending. The category for asylum application EADs is C08. And so if you look at your work permit and it says category C08, that means you received your employment authorization based on a pending asylum application. And so far, pending asylum applications do offer some limited protections. There are some instances in which people who have asylum pending can still be detained by ICE and they can initiate removal proceedings. But asylum is also a defense from removal. And if you have an asylum application pending and you have that work permit, it's the same as all the other things I mentioned. It's not the work permit that protects you. It's the pending asylum application that offers some limited protections. I'm going to end with a quick story. I submitted a U visa application for a client a few years ago. A U visa, for people who don't know, is for immigrants who have been the victim of a crime and who cooperated with law enforcement. It's a pathway to permanent residence, but it takes a while, like 5 to 7 years before you might be eligible for the actual U visa status. And a couple years after that, you could be eligible for permanent residence. When you have a U visa pending for like 2 to 3 years, something that could happen is USCIS can give you a notice that your U visa seems to be approvable. They'll make a bona fide determination and they'll send you a notice saying, we've determined that your U visa application is bona fide and you can use this notice to apply for employment authorization. And so now I'm applying for employment authorization for this client. We just got that notice in the mail. And the client asked me, will this work permit help protect me from deportation? And the answer is no, not at all. It makes no difference whether you have the work permit or not. You're still fully deportable until you have U visa status or permanent residence. And another quick note on that, something that a lot of people don't realize is that you can even have a deportation order, a final removal order, and get employment authorization. There are several ways in which this could happen. One of the ways is if you have DACA, you could have that with a removal order. TPS, temporary protected status, you could have that with a removal order. If you were granted withholding of removal or relief under the Convention Against Torture, what the immigration judge does in those cases is they order you deported, and then they sign another order. It's actually the same order, but it's further in the order that says that your removal will be withheld because you've been granted withholding of removal. So interestingly, those people have a removal order, but they can't actually be deported, except for that guy in Maryland who got picked up and just deported summarily to a prison camp in El Salvador. Legally, you're not supposed to be deported if you have withholding of removal, and you can get employment authorization. That also applies for immigrants who are fully deportable and who have an order of supervision. And sometimes they have a full removal order and an order of supervision. They can still get employment authorization. I'm giving these final examples just to really bring home the fact that you are not protected from deportation just because you have an employment authorization document, even if you were recently issued the employment authorization. All right, guys, that brings us to the end of today's video. If you have any questions, you could schedule a consultation directly with me. You can find my consultation information in the video description below. I focus my practice on family-based immigration and some removal defense litigation. If you need any assistance with applying for a green card or naturalization, or you just have questions about immigration strategy and how best to protect yourself, feel free to schedule a consultation. Otherwise, I'll see you guys next time for another video.